Hello, class. Professor Mandeville back. We were talking about President Adams and the Midnight Appointees and Judiciary Act of 1801. All this is going to lead to the famous case of Marbury versus Madison. Now, what's going to happen here is Adams makes all these appointments to the positions. Two of them we've already pointed out. One is John Marshall. There's a famous portrait of him on page 217. This is the area where your textbook talks about this. And there's Marbury, who was appointed to be the Justice of the Peace of the District of Columbia, a federal position. Now, it's going to be Marshall's job as Secretary of State, which he still is, until President Adams leaves office and President Jefferson is inaugurated. Back in this day and age, when there's appointments like this, where the president appoints somebody and they've been confirmed by the United States Senate, the appointment doesn't become official until the Secretary of State finds the person who was appointed and swears them in. So Marshall, all of a sudden, has his work cut out for him. He's got this whole stack of appointment papers. He's got to find these Federalists who have been appointed by Adams to these court positions before March 5th, when Jefferson becomes president, because he'll no longer be Secretary of State then. Jefferson will have his own Secretary of State, who we'll see is going to be his best pal, James Madison. So Marshall's, scurrying around trying to find all these Federalists, and he's having not much success, because remember, he can't sit in his office and call him on the phone and say, get your butt down here so I can give you your appointment papers. Even the mail system's pretty unreliable. So he's hunting them down, and he's still got a sizable number that he hasn't found, and it's the night before Jefferson's inauguration. And on Inauguration Eve, what happens typically back then and today, in Washington, D.C., there'll be some parties thrown for the outgoing president to congratulate them on a job well done and whatnot, and wish them a fond farewell. This is going on for President Adams because he's leaving office. So obviously the people that'll be attending these events will be all Federalists. So Marshall decides, I'll accompany Adams to all these different parties because that's where these Federalist appointees will be. So he goes with Adams, and sure enough, he finds the majority of all the people he needs to deliver these papers to before the next day, when he no longer has the authority to, because Jefferson will be president. Now, as the story goes, Marshall ends up going to one too many parties, gets a little sleepy, falls asleep, and when he wakes up the next day, he wakes up to the sound of cannon fire. That's the cannons saluting the brand new president, Thomas Jefferson, just being inaugurated. When Marshall looks in his vest coat pocket, there's still a small stack of undelivered appointment papers. So what he's going to do is go to his office, Secretary of State's office, pack up all his stuff, because he's going to move down the street to the Supreme Court. Remember, he's the new Chief Justice. And he's going to leave those undelivered appointment papers on the Secretary of State's desk. Now, in the near future, the incoming Secretary of State, appointed to that position by President Jefferson, former Congressman James Madison, will go into his new office and find these undelivered appointment papers. He'll take them and show them to his boss and friend, Thomas Jefferson. And he'll ask Jefferson, what should I do with these? Obviously, Marshall didn't deliver them in time. So the appointments aren't official yet. Jefferson says, throw them in the trash. I'll appoint new people, and you'll deliver the appointments to my appointees, who will be Democratic Republicans. So that's what happens. So, District of Columbia Justice of the Peace, Marbury was one of these undelivered appointments. He's going to end up filing a suit demanding that he get his appointment delivered to him by now Secretary of State Madison. This is what creates this famous case of Marbury versus Madison. Marbury's attorneys are arguing that there's this clause in the Judiciary Act 1789 that allows the Supreme Court to intervene in matters like this between branches of government and issue orders to solve the problem. So what his attorneys are seeking is an order by the Supreme Court ordering now Secretary of State Madison to deliver this appointment paper to him so he can become the Justice of the Peace in the District of Columbia. Now, obviously, Madison and the Jefferson administration are going to fight this in court. Now, it ends up quickly going to the United States Supreme Court because of the language in the Judiciary Act 1789. This case is in front of the court in 1803. Quickly is relative when it comes to courts. And in this famous case of Marbury versus Madison, the Chief Justice in the case is no less than John Marshall, who was party to the case. He's the guy who didn't deliver the papers on time. Now, you would think that Marshall would recuse himself, step down off the bench, because there's a clear-cut conflict of interest. But he didn't. And the attorneys representing the Jefferson administration didn't question it, because Marshall was a quite honest person, and everybody trusted him to help lead the court in making the correct decision, which he did. In fact, not only is he not going to recuse himself, he's going to write the majority opinion for the court. And in that opinion, he states that the court should order Madison to deliver Marbury his appointment papers, but they don't have the power to do that, because the power that was given to them by the Judiciary Act of 1789 to intervene in these affairs is unconstitutional. One branch can't give another branch additional powers. That has to come in the form of a constitutional amendment. So in essence, Congress skipped a step. So that section of the Judiciary Act of 1789 is unconstitutional, thus null and void. That's the first time in the history of our country that the United States Supreme Court uses its power to strike down a federal law. That is known as judicial review. That's why this case is so extremely important. Every time the Supreme Court rules a federal law unconstitutional, they will always cite in their decision Marbury versus Madison of 1803 gave them the power to do that, because it's not clearly given to them in the Constitution. Marshall was brilliant doing this, because this is going to also clear up some of what the actual powers of the court are and still are today. Now, this also brings us to an interesting thought. What case do you suppose should have been the first case that the United States Supreme Court ruled unconstitutional? Let's think about that. Obviously, it's Lyon versus the United States. Had the court done their job and not been blinded by politics, and accepted Lyon versus the United States, they would have no doubt had to rule the Sedition Act unconstitutional. But they didn't. So, had they done their job, the landmark decision would have been Lyon versus the United States, not Marbury versus Madison. And that's the case scholars would have studied from that point forward. But it wasn't, because the court dropped the ball. So now we want to move on to Thomas Jefferson's inaugural speech, which is a pretty important one, because when you think about it, him taking over as president is sort of like a revolution. We have one party replacing another. It had never happened in American history, and that's why a lot of people call the election of 1800 the peaceful revolution. So Jefferson's well aware of this and well aware of how torn apart the country is. So in his Inauguration Day speech, the first thing he does is try to reunite the country. And he really encourages his fellow Democratic Republicans to put the past behind him, because he announces that he is ordering the Justice Department to stop enforcement of the Alien and Sedition Acts, and that both those acts, due to how they were passed by Congress, expire in 1803. So technically they're on paper for the next couple years, but they will not be enforced. And he also pardons everyone who was convicted of violating them. So, he says, with that done, I want you to forget about it. I don't want you to try to retaliate and seek revenge against the Federalists for this horrible chapter in our history when the Constitution basically was falling apart in front of our eyes. Now, with that said, he goes on to talk about a couple of other things. He's quite concerned about two topics that he's going to devote a lot of his attention as president to. One, he's very worried about us, as he says, and a lot of presidents since then, including President Reagan and others, he points out that he believes that we do not have the right to mortgage the future of our grandchildren. And he's extremely worried about the rising federal debt back then. Now, ironically enough, the federal debt was only about $83 million, but this worries him. Boy, he must be spinning in his grave today when the federal debt is way in excess of $20 trillion now. But that's a different story. So he says we need to do something about this debt. We need to cut back on spending and bring things under control. And he's going to do that right away by announcing that he doesn't believe we need a large standing army during a time of peace. So he's going to significantly cut back on the Army's budget and the Navy's budget. And that will help save money. Now, as we'll find out, during his administration, with his budget cutting actions, he will balance the federal budget. He'll pay off most of the debt during his administration, and by the time he's done, will be debt-free with a balanced budget, which is quite an accomplishment by President Jefferson. Now, the other thing that really worries Jefferson is he's afraid the country might be growing too fast, and that before we know it, we're going to run out of our most valuable asset, inexpensive farmland. And as we already noticed in that map, we've added 3 states and more are on the way. And he knows one thing that makes America great is inexpensive farmland, where anybody basically, if they work hard enough, can own their own farm and be their own boss. And that's what draws people to the United States and drew people here to the colonies. He's afraid that we're growing at too quick a rate and land's going to become way too expensive. So That's one of his worries because he knows that individual small farmers, as far as he's concerned, are the backbone of this nation. Now, what we want to talk about next is how some of his Democratic Republican colleagues don't pay attention to his inaugural address. And they're going to go on a rampage of revenge against the Federalists for the Sedition Act. And what they're going to do, and this sort of makes sense, when they think about it, the real culprits behind it all are the courts and judges. They had their opportunity to hear Matt Lyons' appeal, rule the Sedition Act unconstitutional, and they didn't. So they start investigating judges. Now, judges can be impeached, just like cabinet secretaries and, as we well know, presidents. So they're investigating judges, and they discover that Judge John Pickering of New Hampshire is basically a crook. There's been rumors about him taking bribes, and sure enough, they end up being correct. So they bring him up on, they pass articles of impeachment against him. Then there's a trial in the Senate, and Judge Pickering is thrown off the federal bench. Now, they're not satisfied. They want to go after the top dog, so to speak, the Supreme Court. Now, they start investigating all the Supreme Court justices. Obviously, Supreme Court justices aren't routinely out breaking the law. I mean, you don't really hear about law-breaking justices. Ruth Bader Ginsburg isn't out committing crimes, if you know what I mean. But there is one justice in particular who really hasn't committed crimes, but has some skeletons in his closet. And that's Supreme Court Justice, just a minute here, my name's, Samuel Chase. Now, what he is guilty of is he likes to drink a lot. Now, it's pretty much common knowledge in Washington, D.C., that Justice Chase on some evenings gets a little tipsy in the bars of D.C. and is routinely escorted home by the Washington, D.C. police force, where an average person probably would be arrested for drunk and disorderly. But Chase gets these escorts home. So, Congress is going to pass articles of impeachment against Justice Chase, and there'll be a trial that follows in the Senate. He really had not committed any high crimes or misdemeanors. So the Senate is going to find him not guilty. His only crime is he didn't, know how to handle his alcohol, I suppose. So he's found not guilty, but it's very embarrassing for him and his family. So after that happens, Jefferson calls Congress into his office and more or less reads them the Riot Act and tells them enough's enough, you've had your fun, now leave the Federalists alone. This will only lead to a never-ending political partisan battle between the two parties, so knock it off. Now, one other thing that we want to talk about President Jefferson before we talk about some of his policies, and his most important policy, obviously, the Louisiana Purchase, is if you look in your book on page 213, in this little section on examining the evidence, they focus in on the Thomas Jefferson-Sally Hemings controversy. Now, this was brought up in the campaign of 1800 as sort of scuttlebutt behind the scenes, that Thomas Jefferson had had a torrid love affair with one of his African slaves, Sally Hemings, and as a result of that, the two of them had children together. Now, this was never ever proven during Jefferson's times, but it persisted as a rumor. Now, today, in our modern world with DNA testing, we have proven the fact that Thomas Jefferson and his slave, Sally Hemings, had children together. Now, let me tell you a little bit about this because I don't want you to get the impression that Jefferson was one of those scumbags who snuck out to the slave quarters in the middle of the night and forced himself upon slave women. Sally Hemings was a house slave, meaning you had two different kinds of slaves back then. You had field slaves who toil away in the fields that we typically think of, who are abused and whatnot. Then you had slaves who worked in the house, like the Monticello Jefferson's home. Some of them would be cooks, maids, servants, nannies. Sally Hemings was a nanny. She was an attractive young lady. And Thomas Jefferson's wife died prematurely at a very young age. Now, that meant Sally Hemings almost became the surrogate mother of his two daughters from his dearly departed wife. Now, when Jefferson was the ambassador to France during the Articles of Confederation during the mid-1780s, he was there for several years. He took his two young daughters with him and Sally Hemings, who took care of them while he was busy with diplomatic affairs. That's where, evidently, Jefferson and Sally Hemings fell in love. And Jefferson and Hemings, while they were in France, there are reports, publicly went out together with his two daughters, out to dinner, to museums, to the opera, and didn't hide their relationship because, quite frankly, the French in Paris could care less. Where if Thomas Jefferson and Sally Hemings openly had a relationship in Virginia, where he was from, probably both of them would have been killed because it was completely unacceptable for a master and a slave to have an open love relationship, have children together, and, obviously flaunt this in public. So it was always kept a secret. Now, I'm not trying to justify any of this, but Thomas Jefferson, had he, openly let it be known that he and Sally Hemings had this love relationship, that would have been the end of any career he had and might have cost him his life and hers. To give you an idea of how this was a lasting legacy in America, it was against the law for mixed-race couples to get married in the United States all the way until 1967. That's when a famous Supreme Court decision of Loving versus Virginia, pretty easy one to remember in con law, Loving, a couple, a black person and a white person who had got married in the state of Virginia, defying Virginia state law that outlawed such a marriage, challenged it to the United States Supreme Court, and the court said that the Virginia state law was unconstitutional. It was a violation of the Equal Protection Clause and the rights of this couple. But that lasted all the way until 1967, believe it or not. So, what we're going to cover next is the Louisiana Purchase. Now, I'm going to, since the Louisiana Purchase is a pretty complex issue, I'm going to end this lecture right here, and we'll pick up the next one, and we'll devote it to the Louisiana Purchase and the expirations of Lewis and Clark, and probably, arguably, just as important, Sacagawea. So, I'm going to take a little break. I'll come back and I'm going to tell you all about the Louisiana Purchase. So, see you soon. Bye.